Okay, so we're up to part 4 of our video on the sequential evaluation process. This is attorney James Ratchford, and I'm teaching you today about how a Social Security claim is analyzed by the legal adjudicator, whether that's an ALJ at an ALJ hearing or a lower level evaluator who is just an analyst at the Social Security Administration. So step 3 of the sequential evaluation process is the question of whether the medical condition meets a medical listing. Now this is a very, very big topic that we could spend easily hours on, going into very detailed nuances, and obviously I don't want to stay here with you today for hours going into every possible variation of how this question can be answered, and we really don't need to do that. So what I want to direct you to is I'm going to put a link in the comments to this video that tells you where to find the actual listings, the medical listings themselves on the Social Security website. The medical listings is Appendix 1 to Part 404 of the appropriate volume of the Code of Federal Regulations. It's kind of an obscure reference, and you'll never find it by the reference. You're going to just be able to find it by Googling. Just type into your Google Social Security medical listings, and that's going to get you right to the page that gives you an overview of the medical listings. So let's just kind of I really should just take you through a walkthrough of this page, but until my editing techniques get a little better, we're going to have to settle for a virtual walkthrough right now. So you can go ahead and click in another window, go over to that web page. You're going to find it by Googling Social Security medical listings, and when you click on that link, you're going to get to a page that shows you what's called adult listings, and it's going to have a grid of different bodily conditions, different bodily systems that can be evaluated. And each of these categories is a bodily system such as the musculoskeletal system, the immune system, the digestive system, the pulmonary conditions, cardiac conditions. All of these conditions are categorized into different groupings within the medical listings. So what you're going to do is you're going to click into the relevant medical condition based on the listing that we're talking about. So let's just say, for example, because this is one I know off the top of my head, we're going to look at the mental health listings. So click on section 12.00, mental health impairments. And once we get into that section, it's going to take us to a web page that has a list of medical conditions and very specific detailed diagnostic criteria that apply to each of these medical conditions. And if you're looking at the mental health page, you're going to see that there's a number of different conditions such as bipolar, depression, anxiety. There's even a section for post-traumatic stress disorder. All of these conditions are each going to have specific criteria that go with them. Now we can go into more detail on specifically how to drill down into each different subset of the medical listings, because each of these listings has its own set of rules, and each of those rules has case law attached to it that are going to tell you how these regulations are applied in evaluating the details of your particular medical condition. So it's going to be very complicated getting into the nitty-gritty of it. Now, let me pull back a step and just kind of explain to you what a medical listing is. A medical listing is a set of specific conditions that come in diagnostic criteria and findings, objective findings, measurements, and signs that are all objective in your medical records, with the exception of the limitations for mental health impairments. And the mental health limitations are going to be a little bit different in that they are somewhat subjective. They have to be evaluated by a qualified medical source, what's called an acceptable medical source under the Social Security law. And in the mental health listings, you'll need an evaluation of the degree of limitation that comes from the impairment rather, in order to assess whether that condition is going to meet the listings. But for all of the physical impairments, it's going to be very objective. So for example, you can look at the musculoskeletal system, and one of those listings is for amputation. And those are very clear-cut, if you'll pardon the pun, clear-cut criteria that are going to tell you in unambiguous terms. So for instance, a person is going to meet the listing for amputation if they've lost both hands. Now there's not a whole lot of nuance to it. There's no losing of 1.9 hands. You either have your hands or you don't. Now, there's also, if you lose one weight-bearing appendage and in each of the upper and lower extremities, 1 foot and 1 leg, or I'm sorry, 1 leg and 1 arm is going to be enough to get you there. these are very unambiguous. There's really no way that you could look at a medical record and not be sure of whether these are met. Some of them even have very specific mathematical criteria. So for example, listing 507 is end-stage liver disease, and that has a formula in there that is going to give you specific lab findings, and you calculate them in a particular way. I've actually had to build a spreadsheet to calculate these values. And you're going to come to a score, and then there's a threshold. If the score is above this, you meet the listing. If it's below it, you don't meet the listing. So these are very objective, very rigid. So when it comes to evaluating a listing for whether it's part of your strategy, what's going to happen is your attorney is going to look at your claim and see whether it does meet a listing. And it either does or it doesn't. There's really not going to be a whole lot of arguing to try to prove it. We're not going to have testimony at the hearing that's going to try to prove it, with a couple of narrow exceptions. So some of these symptoms are going to be partially subjective to the extent that you're going to describe to your doctor whether you experience this symptom, and sometimes I might bring that up in a hearing. So for example, on the listing for back pain, for spinal impairment, we're going to have a nerve root issues in the lumbar or cervical spine that are going to have to be satisfied by certain findings that can be found on an MRI, and then certain findings that go from certain objective tests. And then we have what's called neuroanatomical distribution of pain. And that means that the distribution of pain and numbness has to go along a certain part of your body. So, depending on the dermatomes, which is the relation between the level of vertebra in your spine and the level of your body that's controlled. So, for instance, the cervical dermatomes are going to be pain or numbness going down your arm. So I might ask you in a hearing, knowing the answer in advance, of course, I might ask you whether you have pain or numbness that go down a certain part of your body in order to substantiate that you meet that listing for the spinal condition. But otherwise, we're generally going to have a very straightforward, it's either in the medical record or it isn't. Now, with the mental health listings, it's a little bit subjective, but we still need it documented medically. Mental health listings are going to evaluate your degree of limitation in what's called the B criteria. Each of these listings has paragraph A and paragraph B. And paragraph A has a number of different symptoms that can be evaluated for that condition. Paragraph B has a degree of limitation for different functional areas. And paragraph B is going to be the same for a number of different mental health conditions. It's going to be your ability to function in 4 different functional areas, rated on a degree scale from no impairment, mild limitation, moderate limitation, marked limitation, or extreme limitation. And in order to satisfy the listing, you have to have marked limitation in 2 out of those 4 functional areas, or extreme limitation in 1 of those areas. And that degree of limitation has to be assessed by a doctor. You're not going to win the claim without having that assessed by a doctor in your medical records or in a report that your doctor generates for your lawyer. There are, in fact, 2 ways to satisfy step 3. The first way is meeting the medical listing, and that is when all of the criteria in your medical file line up precisely with one of the medical listings. That is very easy. Once we have the criteria, all your lawyer has to do is tell the judge where in the file to find all of those steps, and they can grant the case without really the need for any testimony. In fact, sometimes we'll just write a letter when this is the case and get the judge to grant the case without a hearing. The second way that a case can be granted at step 3 is by equaling a medical listing. Now, this is much more complicated. A condition equals a medical listing when a doctor, in his professional opinion, decides that the criteria that you have in your body are not exactly the same as what is in the medical listing, but are equivalent or close enough. So an example of this might be, just off the top of my head, let's say that if we were evaluating the blindness listing is going to say that if your best corrected vision is 2200 in the better eye, but there are some nuances to it. So, like, you could perhaps have a different kind of visual impairment. Maybe you have double vision, or you have no low light perception, or anything along those lines. You could have a doctor that says, well, he doesn't precisely have 2200 best corrected vision in the better eye, but even though it's less than 2200, it has these other limitations that basically make it essentially the same thing. And there's various other ways in which a doctor can opine, render an opinion that says that you equal the listing, but that's a relatively rare scenario. And we'll have that come up when we're getting an opinion from a doctor, particularly when we're dealing with obscure conditions. When the condition itself is not in the listing criteria, then we may want to compare it to another condition that is in the listing criteria and get it equaled. But we're going to need to do that with an opinion statement from a treating doctor, or from an examining doctor, or from an evaluating consulting doctor. And the best is going to be from a treating doctor. But getting that statement of equivalency is something that is frankly very hard. And to be really candid with you, it's really not something that is typically done at all. Where equaling a listing typically comes up is when a judge employs a medical expert to testify at a hearing. That's going to be a doctor who has expertise in that area of medicine, who is going to come to the hearing and testify to help the judge understand the medical issues, even though that doctor has not examined you. And medical experts can be good or bad. Really, they can go either way. Sometimes they will be my best friend in the hearing, and sometimes they'll be my worst enemy in the hearing, because they can make my job much easier or much harder. And we will ask a medical expert, does this condition equal any medical listing if it doesn't meet a medical listing? And sometimes that doctor will come along and come around to my side, and other times I can argue that doctor into my side if I have an argument prepared as to why I think these particular medical findings equal this particular medical listing. But it's relatively rare, and I wouldn't necessarily be disappointed if your attorney doesn't do that, because most of the time it is not the appropriate argument. So that's step 3 of the sequential evaluation process. Step 3 of the sequential evaluation process is whether your condition meets or equals a medical listing. So definitely consult with an attorney to find out whether your condition meets or equals a medical listing. And the last point I will give you on this is I do strongly recommend that you actually talk to an attorney about whether your condition meets it. Because looking at the criteria in the listings themselves, they can be confusing. And it is certainly possible for you to misinterpret your own medical records. If you believe that your condition meets a medical listing, I still recommend talking to an attorney to verify that it does in fact meet that condition. Because if you think that your condition meets a listing and it actually does not, you could lose valuable time in proving your claim, and you could end up waiting much longer than you would if a qualified lawyer had helped you prove your case early on. So that's step 3. Thank you.